The WOTUS rule is a football that's been kicked back and forth for a long time. It's basically been a battle between the environmental groups on one side and landowners and property rights advocates on the other. Here's the background. The federal Congress only has the authority to regulate interstate commerce. Otherwise, land use is subject only to state regulation. So whatever authority Congress has, it has to be tied to the commerce power. Congress decided it needed to use the commerce power to regulate water use. Now, we don't know if they really consider the constitutionality of that power or not, but that's the power it used when it passed the Clean Water Act in 1972. Actually, there was a predecessor statute prior to that, but the current statute is the Clean Water Act. The Clean Water Act prohibits the discharge of any pollutant into navigable waters without a permit. It defines pollutant very broadly so that it doesn't just include chemical pollutants. It also includes materials such as rocks and sand. The Act delegates power to make rules and regulations to protect those waters. That power is delegated to the Environmental Protection Agency, or the EPA, and the Army Corps of Engineers, or the Corps. At first, the Corps was less restrictive than the EPA, but pretty soon they both pretty much marched in lockstep. And although the law is about protecting the water, what's really happening is it's affecting how landowners can use their land. The Act gives regulatory powers over navigable waters and defines navigable waters as the waters of the United States, including the territorial seas. So the question becomes, do the waters being regulated fall under that definition? If so, the federal government has the power to regulate them, and we refer to them as jurisdictional waters. If not, the federal government has no authority to regulate them. The EPA and the Corps generally want to regulate just about everything, so they've attempted to define jurisdictional waters very broadly. Since 1972, there have been amendments to the Act and to the rules, and there have been some court decisions. And the Sackett case is the latest and most definitive ruling that has come down from the United States Supreme Court. Now, why is this such a big deal? Well, if you're a landowner and you want to actually do something with your land, you may have a roadblock in the way in the form of federal regulation. And you may not know it until you've already started to do whatever you're going to do. So you have a choice. You can do what you're going to do until you get a notice from the federal government saying you need a permit, or you can go ahead and start the permit process. The first step in the permit process is asking for a determination whether your land is jurisdictional, and 75% of the time the agencies determine that it is. The second step is seeking a permit, basically asking the federal government for permission to do what you want to do. And both steps of this process are time-consuming and expensive. So what has happened is that the agencies keep trying to write the rules to give them the most regulatory power. And that's also affected by which administration is in the White House. And there's been a series of court cases attempting to define that power. And with each court case, the rules get changed to comply with the court cases. And then the rules get challenged in court again. Lather, rinse, repeat. The first case was United States versus Riverside Bayview Homes. That case dealt with wetlands abutting a navigable waterway. The court said, those are wetlands. They aren't exactly navigable waters, but we're going to say that since they're abutting a navigable waterway, they're within the jurisdiction of the Corps. So, of course, the agencies responded by expanding their authority in the rules. They introduced the migratory bird rule. That rule basically said that if waters are or would be used as habitat by migratory birds or endangered species, they were subject to federal regulation. That rule was challenged in Solid Waste Agency of Northern Cook County versus Army Corps of Engineers, what we call the Swansea case. And the court said, no, that rule's way too broad. Those aren't navigable waters. They're not abutting navigable waters. We're not going to give federal authority over land use just because a bird might decide to sit down there. So ponds that are not adjacent to open water are not jurisdictional. The agencies responded by saying that ruling only applied in those very narrow circumstances and basically interpreted their rules to include almost any land. If there was an intermittent drainage ditch that only held water part of the time, they were still going to try to regulate it. That brought us to the Rapanos case. Rapanos versus United States. Rapanos wanted to build on a cornfield. It was near some drainage ditches. When there was rainwater, it went into those ditches, then into a series of ditches and creeks, and emptied into navigable waters over 11 miles away. There was no majority in Rapanos, but the plurality, 4 justices, said no, the CWA covers relatively permanent bodies of water connected to traditional navigable waters and wetlands that were closely physically connected so that as a practical matter, they were indistinguishable from the waters of the United States. 4 justices were fine with the federal regulation of the land. The deciding vote was Justice Kennedy. He concurred in the judgment, saying the Rapanos land was not subject to regulation. However, he suggested a test called the significant nexus test. Under that test, he suggested jurisdiction required a significant nexus between the wetlands and the navigable waters. He said that nexus exists if the wetlands, either alone or in combination with similarly situated lands in the region, significantly affect the chemical, physical, and biological integrity of the waters. The agencies took that and ran with it. They rewrote another very broad rule and incorporated the significant nexus language into the rule. Now, what's the problem? All of these cases are decided on a case-by-case basis. So if you're a landowner, how do you know what to do? You can hold your breath and start building, or you can start the process I described before, time-consuming and costly. And if you disagree, you're in time-consuming and costly litigation and appeals. Meanwhile, your land just sits there costing you money. So that brings us to the Sacketts. Now, these are not the Lou L'Amour Sacketts. The Sacketts were a couple who bought a small piece of land near Priest Lake in Idaho. Priest Lake is entirely in Idaho and not in any other state. They were going to build a home there, and they began backfilling the lot with dirt. Everything was fine until they got a love note from the EPA. There was a ditch nearby, and it fed into a creek, and that water ended up in Priest Lake. The EPA said, you have to stop backfilling and restore the site, and if you don't, you're going to get fined over $40,000 per day. The Sackett land sat there for almost 20 years during the dispute. They eventually ended up in court, and that's how we ended up with this decision. The court reached a unanimous decision that the Sackett's land was not jurisdictional, although they had different ways of getting there. They did reach a majority, though. The majority opinion rejected the significant nexus test and said that the Clean Water Act covers only wetlands that are, as a practical matter, indistinguishable from waters of the United States, meaning that the water must be adjacent to a relatively permanent body of water connected to traditional interstate navigable waters, and also must have a continuous connection with that water, making it difficult to determine where the water ends and the wetland begins. The court looked at the history of federal water regulation. Rivers, lakes, seas, etc. have been and are highways for commerce. The statutes were originally limited to keeping traditional navigable waters navigable. Remember, in order for the federal government to have legitimate power over this, it has to affect interstate commerce between and among the states. The court said that some adjacent wetlands are jurisdictional, but if they are separate from those waters, they are not waters of the United States, even if they are near waters of the United States. On a broader scope, Justices Thomas and Gorsuch added that the attempt to expand their jurisdiction is indicative of deeper problems with the court's Commerce Clause jurisprudence. This is not just talking about environmental regulation, but the overall power of the federal government. What they're saying is that the court's previous opinions have interpreted the Commerce Clause too broadly so as to give the federal government power that is inconsistent with the Constitution. 4 of the justices, even though they agreed that the Sackett's land was not subject to regulation, said they thought the court read the rule too narrowly. They argued that adjacent does not mean adjoining and could include nearby waters without a continuous surface connection, such as wetlands separated from waters of the United States by man-made barriers, river berms, beach dunes, and the like. 3 of those justices also cited environmental policy reasons, why such waters should be included, but they did not address the interstate commerce question. The majority, though, said that in order for waters to be subject to federal regulation, there has to be a continuous surface connection. It did mention that a landowner may not avoid regulation by illegally constructing a dam or barrier on wetlands that are otherwise covered. So this is clearly a win for private property rights because it decisively reins in the extent of federal regulatory power over land use. For more information, check out my article, A Nagging Question, in the fall 2023 edition of TG, or on our website.